Hello friends, how are you? Today I am going to discuss an important judgment concerning Prevention of Corruption Act. Friends, in the morning my junior Mr. Baba Mathur had communicated me. He has sent me a citation. When I perused the citation, I got relaxed that in a beautiful manner he has submitted this citation to me by saying that important judgment. But this is not an important judgment. This is an excellent judgment in favor of public servant, duly researched by Mr. Baba Mathur. Friends, be that as it may be, now we are going to discuss the content of judgment and how it is useful for us. Friends, basically, usually, CBI or ACB inter alia mount pressure on the sanction authority to accord sanction. And under their pressure, the sanction usually issued. So in that scenario, what we could do and how we could enforce our rights. So concerning the same, the Hon'ble Bombay High Court recently on 27th of November 2024 pronounced a judgment titled as Dada Sahib versus State of Maharashtra. Case number is 2299/2020. In that case, a FIR under section 7 of PC Act has been registered. Do you know what is PC Act? PC Act means Prevention of Corruption Act. Friends, basically the allegation of Anti-Corruption Bureau is that the concerned accused, being a public servant, had abused the official position, had demanded the money to discharge the public duty in dishonest way. I'm totally perplexed to note down, because in that case there is an uncontroverted position is that the accused merely demanded. Okay, it is not the case of SCB that the money has been recovered in consequence of demand. So the case is confined up to the extent of demand. So we must remember that if the case is confined up to the extent of demand, in that scenario, if the concerned complainant or ACB is attributing that the consent bribe is inter alia connected with the official duty or function, in that scenario, if the accused is not caught red-handed, he may avail the benefit of section 17A of the Prevention of Corruption Act. Friends, please note down that on that point, recently Honorable Rajasthan High Court, in judgment of Ranidan versus State of Rajasthan, judgment pronounced on 8th of October 2024 has clarified the position. Okay, na? Very easier for you. You got the point now? Friend, in this case, the consent ACB, after having the proper charge sheet, inter alia communicated with the concerned sanction authority as per the protocol of section 19 of PC Act. Do you know whether for the prosecution of section 7 of PC Act sanction is required? The answer is in affirmative. Please read section 19 of PC Act as well, in which it has been clarified that no court will take cognizance of offence under section 7 of PC Act if there is no sanction by the sanction authority. Now the important question arises, who will be sanction authority? Sanction authority means the authority who is competent to remove you, not the appointing authority. So who is competent to remove you? Basically, there are certain rules concerning the business which is usually propounded by the concerned government by passing the resolution by which the concerned authority has been identified or notified to act as competent authority regarding the removal of the concerned public servant from his services in case any misconduct is alleged to be reported. Okay, now got the point? Now it is easier. So in that case, the SDM was totally competent for the same. But when the file was put up for permission, it was rejected. And ultimately, the concerned ACB put pressure. Mr. SDM, issue sanction because while rejecting our proposal, you have not taken the approval of Department of Law and Judiciary. And ultimately, this time again, SDM refused the permission. And third time, with the FSL report and with certain confirmation, the matter was re-put up because the ACB is well conversant with the legal position that on new material the sanction could be accorded. But this time the SDM refused the consent permission on the ground that the concerned SDM is not the competent authority as per the new proposal of the concerned government. Now the concerned SDM suggested the concerned ACB to communicate with concerned collector, and in the meanwhile the concerned ACB, as per the order of concerned SDM, communicated with the concerned collector, and concerned collector inter alia accorded the sanction. And this time the concerned accused was agreed because he knew that the concerned law on that point is very much clear. The law point is that sanction once refused, later on the decision cannot be reviewed by any authority, even the higher authority. So in that case, the case is confined to the position of demand only. There is no recovery from accused of any amount. So when there is no recovery of any amount from the accused, in that scenario trap got failed. But when the case is confined to the extent of demand, in that scenario the prior approval under section 17A of PC Act is signed on. Please remember that. And apart from that, if sanction is refused, no new sanction can be issued if there is no material available on the record. The same view is reiterated by Honorable Supreme Court in judgment of State of Himachal Pradesh versus Nishan. And apart from that, Honorable Bombay High Court in case of Chandan versus State of Maharashtra and Dhanra versus State of Maharashtra. It is a recent judgment on that point. So looking into the facts and circumstances, the court specified that there is no new material on the file on record except the FSL report. But FSL report is concerning with matching of voice, whether that voice belong to that accused or not. It is not concerning about the content. So what is concerned about the content? It is a transcript, and by the bare perusal of transcript there is no demand. So court specified that demand should be specific. If by the bare perusal of transcript the demand is not specified, in that scenario accused could not be prosecuted in the routine manner. You got the point now? Now it is easier. So the said judgment inter alia provide us the 5 important guidelines. Please note down that. Guideline number 1, if you are not caught red-handed, the case is confined to the extent of demand only. In that scenario, you could avail the benefit of section 17A of PC Act as approved by Honorable Rajasthan High Court in case of Ranidhan versus State of Rajasthan. Judgment has been pronounced on 8th of October 2024. Number 2, sanction once refused cannot be reviewed again even by the higher authority if there is no material on the record which can be assigned as new material that is relevant or totally alien from the previous one. If there is nothing new on the record on the basis of existing material, reviewing is not permissible again and again by the same authority or by the higher authority. Point number 3 is that the authority who is competent to remove you must be on the record, which is permissible and which is the basic intent of section 19 of the PC Act. If such scenario is not on the record, in that scenario you can take the legal plea, because you must remember that appointing authority is something different from the authority competent to remove you, for which you are required to peruse the concerned business rule used to be pronounced and propounded by the concerned government from time to time. Okay. Number 4, the authority might be changed. So before taking any further action, you are supposed to confirm whether the said authority is competent to remove you or not. If you find the answer in negative, and despite of that the concerned SAB inter alia have the benefit of sanction against you from that authority, in that scenario you may challenge the proceeding on that legal point as well. And number 5th point is that the proceeding for questioning can be challenged on the legal point, because it is not necessary to go on the factual perspective. And if on the legal point there is a crack in your case, and by the virtue of which the case cannot be allowed to be stand, in that scenario you can have the benefit. So these are the basic points which are required to be borne by you in your mind while contesting a case on legal point concerning questioning in the Prevention of Corruption Act. Hope that the said content will boost up your knowledge, and inter alia on the basis of which you could prepare your case and could argue the case by yourself, because it is my wish even to the Almighty God that you must be legally acquainted, you must be legally aware, so that you could contest your case by the virtue of law, and the same is also permissible as per section 32 of the Advocate Act. So no need to worry, just we have to work out on our case, just we have to work out on the factual perspective, we have to work out on the legal point, and if legal point is strong and by the virtue of which we could have a crack in the case, then argue your case without any worry. So see you in the next video. Till then, Jai Hind, Jai Bharat.